In the last episode, I was speaking about claiming asylum, the process of claiming asylum, and the process how the Home Office comes to a decision in an asylum case. And I said that the Home Office might grant you refugee status or refuse you refugee status. In the event that they refuse you refugee status, you might be refused with the right of appeal, or they may certify your application is clearly unfounded or refuse it without a right of appeal. In this episode, I'm going to comment on what happens when the Home Office decides not to grant you refugee status in the United Kingdom. Where the Home Office decides not to grant you refugee status and you've been given a right of appeal, and it is an in-country right of appeal, you have 14 days to submit your appeal to the first tier tribunal. If they've given you a right of appeal to appeal from outside the UK, you've got 28 days from the day that you arrive in your country to submit your appeal to the first tier tribunal. The process of submitting your appeal has been moved by the first tier tribunal to an online application. You now have to submit your application, or rather your appeal online, through the .gov.uk website, and the process is quite simple. You enter your details, you enter the reason why you are claiming asylum, and the whole process will be managed online. If the Home Office responds, and then updates will be sent to you to your email as what is to happen and what you need to do and how you need to submit it. And you might go for a case management hearing, or you might not go for a case management hearing. You will also need to submit your bundle online, and the Home Office will also need to submit their bundle online. It is quite important for you to respond to each and every point that has been raised by the Home Office in refusing your asylum application. It is you can do this by making a statement with your solicitor or your representative, responding to all the reasons raised by the Home Office. It might be reasons for credibility, that they did not believe your case, or they might have believed your case and they are saying that you have got other options. For example, they might state that there is sufficient protection in your home country. You need to produce evidence to show that you don't have the sufficient protection. Or in some cases, they might argue that you might need to move from one part of your country to another part of your country where you can have where you can be safe from whoever is your persecutor. So you need to do a statement, you need to get evidence, you need to get online information. You might need to instruct an expert and get all your witnesses who might appear on your behalf in support of your case. All this information needs to go into your bundle, and the bundle is then submitted to the court online, and the Home Office is normally the first one to submit its bundle online as well. In the court hearing itself, it is important for you to arrive early at the hearing center. When you arrive at the hearing center, please, it is also important for you to inform the caseworkers and the staff at the court that you have arrived. Otherwise, they would not know that you've arrived, and your case might be heard in your absence, or might have to be postponed because you have not notified them. It is also important to arrive early, especially if you are being represented by a barrister whom you might not have met because you were dealing with your solicitor in the office, and you might be needing to brief your barrister on your case. So once you arrive at the court, register your name with the clerks of court, and they'll tell you where to sit and where to wait. And everyone is normally required to arrive at court at 10 o'clock, although it does not mean that your case is going to be heard at 10 o'clock. It might be heard later on than 10 o'clock, or might not be heard given to yourself. In the court, if the judge is female, you address her as ma'am or madam. If the judge is male, you address him as sir. And in the court, it's normally yourself, your representative, the judge, sometimes the clerk of the court, and the Home Office representative. If you cannot speak English, then an interpreter of your own language will be there. The judge will normally come into the court, and when the judge comes into the court, everyone stands up, and then the judge will make introductions of whoever is in the court, and your representative is asked to lead your case in the court, which is normally asking you your name, your date of birth, your address, adopting your statements, asking any supplementary questions. The Home Office is then entitled to cross-examine you, to ask you questions emanating from your statement, emanating from your evidence, and also emanating from any documents that you have submitted. And you have got a right of reply after the cross-examination through what is called re-examination from your representative. After you've finished giving evidence, and if you've got any witnesses, they are called into the court, because the one and by one they will be called into the court, and they will give their evidence, and they will go through the same procedure and process of being asked questions, cross-examined and re-examined. And once all the witnesses have given their evidence, it will be time to make submissions. The Home Office will make their submissions why you should not be granted asylum, and your representative will also give reasons why you should be granted asylum. They will also comment on the human rights and then other grounds that are applicable in the case. The judge does not make it time to consider the evidence submitted, and they can make a decision later on, normally within 3 weeks of the hearing. So that is the process of the appeal. However, I stated that sometimes you might be refused your application without a right of appeal, legal advice from your representative or your solicitor. One of the things that might be available to you by way of redress is seeking what is called judicial review. For the process of judicial review, you will first of all submit what is called a pre-action protocol, giving the Home Office 14 days to respond. They may respond, they may not respond, and they may respond with the decision that you are not expecting, and then you can still continue to challenge them. It is important to note that you should submit your application for permission for judicial review to the court, which is most likely in this case to be the upper tribunal, within 3 months from the date of the decision. Not the date that you were served the decision, but the date when the decision itself was made. So even if the Home Office delays in answering to your pre-action protocol later, it does not have to stop you from making your application within the deadlines, because if you don't stick to the deadlines, then you are likely to lose your right to a redress. If you have submitted your application for permission for judicial review, there's a fee that is payable to the court, a court fee. You pay the court fee, you submit 3 bundles. The court stamp the bundles, they will send you back some of the bundles. You have to save a copy of the bundle upon the Home Office, upon their representative, the GDL, and they will also then have a right to respond, an acknowledgement which they will do and respond to your case. Normally, the judge will make a decision based on the papers that have been submitted, in other words, your bundle and the response from the Home Office, and the judge will make a decision whether or not to grant you permission to continue with the judicial review. If you are granted, then that's fine, you can then go for the oral hearing. If not, you can make an application for an oral hearing, again paying a court fee, and then it will be considered by a judge who might decide in your favor or not in your favor. It is important to note that when you are doing the judicial review application, you will be liable to the costs of the Home Office if you lose your case, which you might have to agree with the Home Office, or might have to be taxed or billed so that you can pay the Home Office costs. The process is quite technical. It requires you to have legal advice, maybe from a solicitor or your representative, because from the permission of for judicial review orally going forward, you might then have to appear in court, make other processes or applications as you'll be proceeding with your case. So basically those are the two ways which you can challenge the Home Office, either by way of appeal or by way of judicial review. If both ways doesn't produce the result that you are expecting, in other words being granted leave to remain on as a refugee or a humanitarian grounds or under human rights, then you might have to consider making what is called a fresh claim or making further representations. So in the next episode, I'll speak about making further representations where your application for asylum or human rights application has been unsuccessful. My name is Andrew Nyamayaro. I'm a solicitor of Tan Law Solicitors, and thank you.